Hello, my name is Michael Kozakowski, and I'm a fellow at the European University Institute in Florence, Italy. It is my pleasure today to welcome Professor Lucia Zedner. Professor Zedner is a law fellow at Corpus Christi College, Oxford, a professor of the law faculty of Oxford, and conjoint professor at the University of New South Wales in Sydney, Australia. In 2012, she was elected to as fellow of the British Academy. Professor, it is a pleasure to welcome you to our program today.
Thank you.
Professor, you've written many different books over the years, starting with a really fascinating study on gender in Victorian England and the idea of crime, and some of your more recent book on preventive justice. I was wondering if you could describe a little bit about what first got you interested in the subject of criminal justice, and how you would describe your trajectory and evolution of interest over time.
Well, it's a long story, so I'll keep it short.
Okay.
I started life as a historian, insofar as I have any academic training. It's as a historian. My doctorate was in the history faculty at Oxford, as you say, studying the history of women, crime and their confinement in prisons in the 19th century in Victorian England. But I rapidly became interested in more contemporary and even modern developments. I also got rather tired of working in very dusty underground archives. And so I retrained as a lawyer, but I've always kept that historical interest and I guess the historical training. And so I've spent the last 25 years teaching in law faculties, initially teaching some legal history, but for most of the 25 years teaching criminal law, legal theory and studies in various courses in criminal justice.
Wonderful. I was wondering, much of your work actually talks about this trade-off that you described very eloquently between liberty and security. Could you tell us a little bit more how you see those two principles and goals working in conflict and in cooperation?
Well, I've been working on questions of security for over 15 years now, and in fact there's a certain hierarchy of those of us who were thinking about questions of security before 9/11, who were in the game, as it were, when that tragic event struck. But one of the long-term considerations that I've been, as a historian, have been playing with is the older construction of security, not just security from those who would threaten us, from terrorists, from criminals, from dangerous offenders, but thinking about the older classic conception of security that one finds in political liberal theory, namely the security of the individual from unwarranted intervention in individual liberty from the state. And so there is this dual-edged conception of security which encompasses liberty, and yet, as we're all very familiar, many of the developments in security provision, counter-terrorism, criminal law over the last 15 years, and one could go back much further, have the effect of limiting individual freedoms and create a risk of security to individuals from the state. So there's a very complex relationship there, which continues to intrigue me.
Could you describe a little bit more sort of those historical precedents, if we think of, say, post-1815 Britain, for example, and a certain clampdown on the masses in the name of the security of the state. Do you see historical precedents to some of the actions being taken now?
Oh, absolutely. And if one goes back and looks at the very founding of the modern police force, take the British example, which I happen to know best. The founding of the British police force was intentionally as a preventive police force. In fact, the police were in their original guise called the Preventive Police. And yet, at the same time, a lot of the debate around the development and institution of the police was framed in light of and by reference to fears about the Napoleonic police state, against which the British were very anxious to distance themselves and to create a policing body that did not constitute an overbearing arm of state authority, of state coercion.
That's very interesting. I was thinking about the idea that's also present in this trade-off, and that is of risk. And the real difficulty, and political psychologists talk about, but the real difficulty individuals have and collective entities have in assessing risk and drawing that balance. And I was wondering, do you see a distinction between individual assessments of risk and what happens when we move to the public sphere?
There's a very interesting distinction there, because what happens when one moves to the public sphere is that one's talking, I think, not only about the actual risks of a catastrophic attack or serious crime occurring, but actually also the risks, for example, to reputation of politicians and security chiefs if that event is allowed to occur. One sees also subjective assessments of risk by the general public and demands by the public for protection, which also work into political debates about what is necessary, which may be quite distant from the actualities of the risk. And then there's also a tension between the development of so-called actuarial risk assessment tools, namely tools based broadly in statistics, and the difficulty, particularly in the counter-terrorism sphere, of applying those actuarial techniques when the numbers are simply too small.
Right, and this is actually, it has parallels to assessing sort of risk in financial markets where, where crises, catastrophic crises actually occur with relative infrequency, and yet the risk to damage or reputation are much greater. I'm wondering, thinking about risk and how risk might seem different if we're talking about us in the sense of citizenship versus the risk that might occur overseas to other people, to non-citizens. And I was wondering if you could say a little bit more about the argument that you've developed about how the law is in some ways founded upon a certain notion of citizenship.
Yes, and I'll be talking about that much more in my lecture. And one of the really intriguing and I think for me increasingly problematic distinctions is both between citizens and non-citizens, but even within citizenship, different tiers of citizenship.
Okay.
If you like, I mean, it's a little bit like the grades one gets when flying. There's club class, and then there's frequent flyer, and then there's economy, and there are categories of citizenship which are altogether more precarious and more conditional than, for example, birthright citizens. So I think we would be in danger of drawing too simple a line if we simply made a distinction between citizen and non-citizen.
Non-citizen. And you're not just referring to those who gain citizenship by naturalization who have been more at risk of being denaturalized in recent years. You're also talking about among born citizens who are born in a given country.
Well, let me give you one immediate example. My husband is Australian, and we thought it would be nice if our children had Australian passports. By applying for and obtaining Australian passports, we rendered our two daughters dual nationals. By virtue of that, we render them liable to deportation because they now have another state to which they could be deported, and there's no risk of statelessness if they were deported. Now, I should say that they would have to commit a very serious offence to be eligible for deportation, but they're now eligible for deportation in a way that they weren't when they didn't own that second passport.
That's interesting. One of the things I was thinking about in your work is so much of law is of course national and grounded within the territorial jurisdiction of the nation state and its jurisdiction over its citizens, which are not always the same thing. And thinking about when you're talking about rendering someone stateless, that of course is a prohibition found in sort of the corpus we know as international law. So I'm wondering how we might sort of conceptualize different national bodies of jurisprudence, both in relationship to one another as well as to international law written with a capital I.
How long do we have? That really is an enormous question, and be absolutely clear, I'm not an international lawyer. I have an interest in international law. I'm not even an immigration lawyer, though I have a strong interest in immigration law. And I think perhaps I can give you, and this is evading the question, so let's acknowledge that, but I can give you an answer which I think is pertinent, namely that what one's seeing increasingly is both a convergence and a colliding of international law, of national criminal law and national immigration law, such that insofar as there ever were clear or bright lines between these different bodies of law, those are no longer as clear as one might think. And indeed, what one sees, and this is the part that really intrigues me, is the ways in which criminal law and the criminalisation of immigration offences is being increasingly resorted to by governments as a way of controlling migration. So you get so academics label it crimmigration, that is the criminalisation of what was once simply an administrative violation of immigration law. But at the same time, you get the resort to immigration law as a tool of criminalisation and security. So just to give some examples, post 9/11, recourse to immigration detention as a means of detaining indefinitely and without trial foreign nationals who were deemed to pose a risk to national security.
And you're not just talking about Guantanamo Bay, are you?
No, actually, in the precise example I was thinking of was a British example, which I'll be talking about in my lecture, which is the creation of a category of the foreign nationals suspected of involvement in terrorist activity, who could, under a law of 2001, could be detained indefinitely in the UK.
And that touches upon one of the other themes that's been recurring in a lot of your recent work, and that's of prevention, prevention of crime. I'm wondering if you could say a little bit more about this notion of preventive justice, how you got interested in it, and what's sort of novel about it.
So the last question is really interesting, is it?
Is
it novel? So last year I published a book with my colleague at Oxford, Professor Andrew Ashworth, and we were very concerned, and the book's called Preventive Justice. We were very concerned in that book to make clear, against the claims made by many academics that preventive justice is somehow new, or that there's been a preventive turn or a changing paradigm of prevention, that actually the impulse to prevention can, as I mentioned earlier, be traced all the way back at least until the 18th century. And indeed, the term preventive justice can be found in Blackson's commentaries on the laws of England from the mid-18th century. This is not a new term. What's new, if anything is new, is the frequency and the willingness of governments to have recourse to preventive measures in the guise of providing public protection from harm.
Which raises the question: what is it about the political system that may facilitate this sort of increasing willingness towards preventive justice and being quite open and frank about it? David Cameron, to name just one example, it is quite explicit that this is a goal that he is openly pursuing, and he's not alone, of course.
There are numerous possible explanations, but let me give you one, and maybe we can discuss others if need be. But one is the degree to which certainly criminal justice, penal politics has become popularised, that the public demands protection of their interests, their families, their homes, their children. And governments and politicians are extremely acutely aware of the pressure upon them to provide that protection. So there's one of my colleagues, Peter Ramsey, has written, I think, very interestingly about the idea of the vulnerable citizen, the claim that we are, in some sense, vulnerable, that it's the role of the state to protect us, that people who threaten us fail to reassure. And it's not simply that they any longer are required to pose an actual threat or directly to threaten us, or that there should be some imminent harm, or as some American jurists call it, vivid danger. Simply failing to reassure becomes a sufficient ground in many spheres for forms of intervention, forms of restriction, forms of deprivation of ordinary rights under this larger paradigm of preventive justice.
Which raises, when you talk about the deprivation of ordinary rights, and I wonder what are some of the things that get lost, or what are some of the trade-offs in this, whether we see it as this move towards preventive justice. What is lost? What are some of the ethical, the social, the economic costs of that, and what might some alternatives be?
Another huge but excellent question. So one of the things that's most striking in the legal sphere is the development of means and procedures that operate outside the ordinary remit of the criminal law. And the argument there is that the criminal law kicks in too late. Typically, it's only really interested once there's a body on the ground. I mean, that's not true, because we've also seen a massive expansion of liability in criminal law for so-called inchoate offences, attempts, incitement, conspiracy, and so on. Exactly. But one of the really striking developments has been the use and recourse to administrative measures, civil preventive orders, hybrid civil criminal measures which are imposed upon people, first of all, in the civil sphere and with lower procedural protections and lower standard of proof. But once somebody's subject to one of these preventive orders, if they breach it, they're liable for imprisonment for up to 5 years under English law. So what one sees again there is a blurring of lines between the criminal process with the particular rights that pertain under the European Convention of Human Rights, not least Article 6, right to a fair trial, Article 7, right against retrospective application of laws. Those are got round, if you like, by recourse to the civil and the administrative sphere. And if you were a conspiracy theorist, you might say that they were developed precisely to evade the protections of the European Convention of Human Rights.
The other issue that this makes me think about is you talked about sort of a performance of reassurance that is expected of politicians these days, and perhaps less transparency. If we think about a lower burden of proof, things working outside the normal criminal justice system, I'm thinking about how important is this idea of a fair, not just a fair trial that goes through due process, but also this idea of transparency and knowledge about the risks that one runs as a criminal, as a citizen, in terms of these competing goals.
I think transparency has probably been one of the biggest casualties of these developments. And let me just give you one illustrative example. I could give you many. The one that strikes immediately to mind is the development of secret or so-called closed material proceedings. So a basic principle of criminal justice, of criminal law, is that one has a right to a fair and open trial and the right to know the case that's laid against one. What we've seen in the English context, the British context, is the development, first of all in the immigration sphere, of so-called closed material proceedings for the hearing of immigration appeals tribunals where there's said to be a matter of national security at risk. So if, for example, the material that is germane to the hearing is such that it might put at risk the safety of the security services or their operatives or their informants, then it's possible under immigration law to hear the entire case in closed material proceedings, where specially security cleared lawyers have access to the material, but once they've had access to that material, they're no longer permitted to have any communication with their client. So complete loss of client-lawyer privilege. That was brought in the immigration sphere. Over the course of the last 18 years or so now, what one's seen is an expansion of that provision, first of all into, for example, parole hearings within the criminal process, but last year, for the first time, the holding of a criminal trial, an ordinary criminal trial. Originally it was intended to be wholly in secret. The Court of Appeal in England said, no, that's a breach of justice, that's too far. But what in fact happened was a trial that was held substantially in secret for the first time since, and this is a cliche, but since the Star Chamber. I mean, it really does feel like the resurrection of something really rather nasty.
Right. Before we close, I wanted to think about where your work is going. There seems to be a topic, preventive justice, that's not going to be going away anytime soon. Well, I'm curious about your own sort of academic interests and what comes next.
On the first of those, preventive justice, I worked for nearly 5 years on that topic, first alone and then with my colleague Andrew Ashworth. And there's always a danger as an academic that one becomes best known for the last book, and that's delightful and a privilege. It's also potentially a burden because one's expected to continue to maintain the interest in that subject, and I am interested, not least because, as you rightly say, substantively, politically, it's not going away. If you ask me what I want to do next, it's not more of the same. I've never been the kind of academic who can bear to sit discussing the same subject for decades. I think my most immediate and present interest is, as I mentioned earlier, in this convergence between and conflict and collision between criminal law and immigration law.
It's very interesting. I'm afraid we're out of time, but before we close, I wanted to thank you once again for joining us today, and we look forward to your lecture this evening.
Thank you very much, and thank you